chance to review those?
Motion?
I'll make the motion to approve the November 6, 2025 minutes.
Motion's been made. I need a second.
A second.
Second by Tommy. All in favor say aye. Aye. All right. Minutes approved. Second order business, swear-in speakers. Charlie?
Everybody signed in to speak tonight. If you can stand and raise your right hand.
Well, we need to find out how
You swear a firm statement you make tonight to be the truth, to the best of your information. Thank you.
All right. Old applications, we have one which has been postponed. Is that correct? So moving on to new applications, S 2025-34.
Is that the use permit?
That is,
That is the use permit?
yes.
Okay, that works. Okay.
Good evening, Board and Honorable Mr. Perkins. Our first application this evening is a conditional use permit for a secondary residence out there on 1039 Glass Pike. A1 zone parcel, of course. It's just under 23 acres in total, near Long Lick and Seabury. Staff is recommending approval. This is an overhead view of the property. I'll show a little better star here in a moment of the proposed location of the house, Glass Pike being there to your northwest. And that star there is close, a staff approximation of where this gentleman would like to place the house. Conditional use permits basically gives you all, the state gives you all the power to review and either approve or not these permits, essentially based on the impact of the surrounding community. Section 412 of our zoning ordinance within the A1 zone does give applicants the ability to apply for secondary residences at each additional increment of 5 acres, essentially. Those do have to be for family members or farm workers. The applicant has stated in good faith to staff that the secondary residence is for an immediate family member. Let's see here. And being almost 23 acres in total, this parcel is more than eligible for a second residence. Oh gosh. Let's just talk about it. I don't know whatever happened there. Something got duplicated. So again, this gentleman has essentially almost 23 acres in parcel size, so there is an existing residence on the property. They have more than allowable amount of acreage for 2 homes. They still propose to use the same entrance off Glass Pike, shared gravel driveway internally. There is an accessory building on the property as well that has no bearing on this application. I believe the home's going to be around 300 or so feet removed from Glass Pike, about 200 or so feet from the existing residence. Typically, we ask that they do it at least 100 feet in the event of subdivision of the property, and then they're going to be 76 or so, 75 feet off the nearest property line. All those dimensions make this application compliant with our requirements. This was submitted by the applicant. I probably got some of those numbers wrong, but it was more than what we need. So again, that primary residence is much closer to the road there. Got more than our 100 feet of separation, and we got more than our 50 feet of required setback as determined by the zone. Again, we've got almost 23 acres in an A1 zone. The applicant is within their rights to apply for the secondary residence. Staff finds that there's more than enough acreage. The placement of the home itself more than complies with all of our dimensional regulations and standards. As such, staff finds that the recommendation of approval would be appropriate by all of our standards. Essentially, with our secondary residences, we just list that they comply with our standards, state and local codes. They pull a building permit before the construction of the residence, and then they also get with the health department and make sure their existing septic and sewer system is suitable. Beyond that, we typically don't have any other applicable requirements given the nature of this request. If you have any questions, I'm here. I believe the applicant is as well.
Has anyone called in or had anything?
No,
Questions? Okay.
no.
Janet? did you have one?
Okay, Red, I just came from these properties that we've got tonight. Okay, standing in front of the existing house. Okay, will this house be to the right of the front of the house and back a little bit? I'm trying to get it back.
Yes, yeah, it'll be, if you were standing in Glass Pike, you'd be backing a little bit, to your right. I can't necessarily say it's east. It's falls away down towards, it'll be still about 75 feet off that nearest property line. But to the rear, same shared driveway, no new entrances on the glass. It's county jurisdiction, I think, in that section anyway, so if they were to ever put in a second entrance, they need at least 250 feet and permission from the county.
Does anyone else have any questions for staff? applicant, you're good for now.
Okay.
Is the applicant here? Do you have anything you would like to add?
No, ma'am, I think he did all the basics on it. It's pretty much, it's just, I'm trying to get my mother moved out there. She's lived in Scott County for the past 35 years, and I'm just trying to get her closer to home so she can spend more time with her grandkids and all that stuff. So it'll never be subdivided or anything like that. And like he said, it's already got an existing driveway right there. So, but yeah, to answer your question, it's to the right of where the house is and further behind it. So it's basically straight behind where my barn is on the right side of the house. So
Okay.
not a whole lot to it other than everything he said. So.
Does anyone have any questions for the applicant? Nope.
No,
nope,
I
sir.
love that it said who it was for on the
Yeah,
application.
yeah.
That was nice.
Yeah. All right. Well, Charlie, unless you have something, I guess we can entertain a motion.
No, I'm anxiously awaiting a motion.
All right.
I make a motion to approve
Second.
S 2025-34 based on all the conditions of approval.
A motion been made and seconded. All in favor, say aye. Aye.
Aye, sorry,
All right, motion's passed.
sorry.
Thank you.
Yeah, I appreciate that you explained it when you said the Bible.
Yeah.
And that it had, who it was for.
More information's
Because I
easier.
feel like we have to pull that.
Yeah, I know.
How to do that in the past with the,
Like, give your reason.
yeah.
All right, moving on to the next application, S 2025-35, TriStar Roofing. Toshi?
Good evening, everyone. This case is a variance request for the property located at 1131 Delaplane Road. The applicant is requesting approval of a variance to reduce the minimum side yard setbacks on both the east as well as west of the property from 50 feet to 38 feet in order to construct a single-family residence. The subject property contains 0.8 acres of land and is zoned A1 agricultural and is accessed from Delaplane Road. Overall, staff recommends approval for this request. This is a aerial view of the property as shown. This is just an illustrative map showing the proposed residence with the proposed setback requirements. In reviewing this request, the board is reminded of the criteria outlined under KRS 100.243, which governs the granting of variances. Before a variance may be granted, the board must find that the variance will not adversely affect public health, safety, or welfare. It will not alter the essential character of the general vicinity. It will not cause a hazard or nuisance to the public, and it will not allow an unreasonable circumvention of the zoning regulations. The statute also requires that the request must arise from special circumstances that are unique to the property, not self-imposed, and the strict application of the ordinance would cause an unnecessary hardship or deprive reasonable use of the property. It is also applicant's burden to provide evidence justifying findings of fact satisfying KRS 100.243. In terms of site conditions, the subject property is around 0.8 acres in size with dimensions roughly around 130 feet in width and 330 feet in depth. Because the A1 district requires a 50-foot setback, side yard setback, and a minimum lot size of 5 acres, this parcel is significantly undersized, which is approximately 84% smaller than what the zoning district typically requires. When the required 50-foot setbacks are applied, only about 30 feet of buildable width remains, which is not sufficient to accommodate a single-family residence. This is a site plan provided by the applicant showing the setbacks that are proposed. And in terms of applicant's justification, They propose to construct a single-family residence measuring approximately 40 feet in width and 94 feet in depth. To accommodate this structure, the applicant is requesting to reduce both the west and east side yard setbacks from 50 feet to 38 feet while meeting the front and rear yard setbacks. The variance on the west side, as shown in the plan, is requested to allow a covered porch, while the variance on the east is necessary to accommodate the residence itself, as the lot does not have adequate width. The applicant states that narrow lot size creates unique physical constraint that do not apply to typical A1 parcels, and that the requested 12-foot relief on each side represents the minimum necessary variance to reasonably develop the property. These are few of the drawings of the proposed residence provided by the applicant. In terms of staff review, staff finds that the lot's unusually narrow width constitutes a special circumstance, as typical A1 parcels do not exhibit this limitation. This unique site condition directly restricts the available buildable area and justifies consideration of a variance. Staff further finds that strict enforcement of the 50-foot setback side yard would deprive the applicant of the reasonable use of their land. With only 30 feet of buildable width available, the applicant would not be able to construct the single-family residence while maintaining the required front and rear setbacks. This hardship is not the result of actions taken by the applicant, and the physical limitations are inherent to the parcel and existed prior to the applicant's development proposal. Again, in terms of findings, the project site is 0.8 acres parcel zoned A1. The minimum side yard setbacks in A1 zoned parcels are 50 feet, and minimum lot size is 5 acres. The lot's narrow width is found to be unique physical circumstance specific to this parcel that severely restricts the buildable area and justifying the need for a variance. The requested reduction of side yard setbacks from 50 feet to 38 feet is the minimum relief necessary to allow reasonable construction, preventing necessary hardship on the applicant by otherwise depriving them of the reasonable use of their land. This variance for residence placement would not adversely affect public health, safety, or welfare. The reduced setback will not alter the essential character of the general vicinity, and this request satisfies the intent and findings required under KRS 100.243. Overall, in conclusion, the staff recommends approval of the variance request to reduce the side yard setbacks from 50 feet to 38 feet for the construction of the single-family residence at 1131 Delaplane Road, with the following conditions of approval as listed in the staff report. Thank you.
Does anybody have any questions for
Yes, I
Toshi?
do. Is the applicant going to live in this house?
Yes.
Okay, now, also, one other question. It's approximately 0.8 acres.
Yes.
Okay, how does this tie in with the 5-acre minimum?
Grandfathered again?
Could you repeat your question?
Can you answer that? You're aware?
Yes.
At least from what we can identify through the information available, that,
Thank you.
and the information that we have available to us about the parcel indicates that it was formed prior to the adoption of zoning ordinances, and so it just got placed in the A1 zone because that is the default zone we put everything in unincorporated Scott County into.
When
So-
was that, Charlie? 72? 72.
Yeah. So this is considered a pre-existing lot of record.
Okay. So you all right with that, Charlie?
Yes.
Any other questions?
Yeah, there's the two right here.
Is the owner here?
Yes.
Do you have any intentions, since you got a roofing business, do you have any intentions of running your business out of the house?
No, sir.
Okay.
I actually own the property at 1121 Delaplane Road. My son lives in that property. And my intentions are to move in there. I'm gonna build a house beside my son, basically. Similar to what the other gentleman is doing, just a
I
little
think it
different.
was just confusing because the applicant was listed as a business and not as an individual, right?
Okay, what is your name?
My name's Lindsay Mosley.
Lindsay Mosley, okay.
Yeah, my company will actually own the property.
Okay.
That's the reason it's the applicant. And, but I do plan on, if you look at the plans, I'm putting a golf simulator in the back, so I'm planning on.
So
living there.
business-owned property, your business?
Yes.
But you're gonna,
Yeah,
okay.
but I have an office in Lexington as well, you know what I'm saying? I mean, I'll do a little home office stuff, nothing nobody doesn't do, but, you know, but like it ain't gonna be an everyday office where people rolling in and out of.
Okay. Anyone else have any questions?
I don't know. Looks like there's floodplain. I didn't see that mentioned in
There is in the back, it'd be like if you're looking at it from the front, like the back right corner of the lot, a little bit of, a little section of it does come into floodplain. It really doesn't affect any of the buildable area. It's in the 50-foot setback. You had to build the property line anyway. So no, it's not, the house, and like I said, I own the residence directly to the left of it from the rear anyway. And that garage you can see on that picture there, it's deeper than what that house would be, and it's actually the lot to the very right of it. If you look in front of that house, it's a 5-acre tract.
Is this like a barn dominium?
That's what I'm planning on building, yes, ma'am.
Okay, I was looking at it and it looked like it from the side, but the front didn't look like a barn dominium.
Yeah, it's kind, I don't know,
Yeah.
the artist rendering probably does better than that picture there, but it should be a nice looking, well,
It's actually a word.
Barn
It's
dominium?
just regular stuff.
yeah.
I've heard people doing that, I've never heard it
He's
named.
already said he would
Yeah,
have
there's
tax.
several on bonds, just like close to me.
Okay.
That's new.
They're a neat concept. I mean, you know,
Yeah.
they build extremely friendly, if you will, if there is such a word.
There's like a giant one back there.
So, just for clarification, so you'll just do normal business as a person would in their house, but you're not gonna have like clients coming in and out or any kind of actual business hours
No, ma'am.
at your house?
I don't,
Okay.
yeah,
Okay.
my business is on the road, it's not the house.
Okay.
Like I'll be in Owensboro tomorrow morning working, you know.
Yeah, well, just checking, because it's his business's house. I was just trying to make sure we were on the same page.
No, we don't have no intentions of putting
Okay.
a business there, for sure.
Does anyone else have any questions, Tommy?
No, but I'd like to make a motion for approval, adding one more condition of approval that no business is to be ran out of the house, strictly residential.
I thought that was already a part rule, but I don't, it's fine either way.
When you said that.
One's in black and white.
Well, when you said the golf simulator,
Mhm.
I didn't know if that was gonna lead into a business
No.
venture. That's personal use.
Oh, yeah. Yeah, I mean, that is, I don't, yeah.
I'm just asking.
I know, you probably think about, they do the rental.
They do?
Yeah, I wouldn't be interested in doing that, no.
So we got a motion.
All right, so we have a motion on the board by Tommy. Take a second.
I'll second.
Seconded by Janet.
Nobody's called with any concerns, right?
No.
Awesome. Okay.
All in favor? Aye.
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 Motion's passed.
Thank you very much.
Tommy's ready to get out of here.
I just want to make sure there was no.
No. All right, thank you,
I like
thank
that.
you.
Tommy, that was good.
So I guess we need to vote on this?
Yes, so that is, the chart kind of provided to you guys is the schedule of the meetings for the upcoming year. If there are no edits or complaints about the dates, we will need a motion to adopt them for 2026.
Can I ask a question first?
Sure.
We've talked about this before, and I notice it's still in there. The affidavit of compliance with everything is still not due until a week after the application. Not that it's been as big a problem this past year as it has been in the past.
Yeah.
But why isn't it to be filed with the application? And we've had people
I had to
on
take
the
a
agenda and
guess.
taken off the agenda, and I mean, why don't we just?
If I had to take a guess, a lot of people will walk in off the street or print an application online, and then they go, oh, I also need to go and get this.
And then tell them, and as soon as you get back here, we're gonna put you on the agenda. I mean, as I said, we haven't had that problem lately a lot, but we've had dozens over the years where people on the agenda, taking off the agenda and whatnot, and in fact, a couple of them never got the affidavit in. So why don't we just get them all at one time?
Y'all have to get, what's his name?
We can get a policy document together, get a vote from the board, and then we'll make it the thing going forward, unless you would advise that it would
I
just.
don't know if the board ever adopted that in the
Board.
first place, that's just,
Point of clarity though, to make it different, unless it matters, the Georgetown board adopted the same structure.
they should do the same thing.
I'm not
I
saying-
just didn't pay attention when the Georgetown board did this. I'm assuming you saw it too. Yeah, I just looked at the dates on that, and I didn't pay attention to the fine print. Anyway, that's just a suggestion, 'cause that's been a problem in the past, although it has not been in the last few months.
Yeah, prior to, I'd say maybe 2 years ago, we had that big issue with it, and where we made it a requirement where your mail had, in order for us to send mail,
You made it that week thing.
yeah, we made it the week thing. But if we're identifying it and if it is the board's pleasure, we can take action to make it a policy to then proceed accordingly.
Now leave it alone.
Well, you're our legal counsel on it. Janet, is there something with the schedule that you have an issue with? I'm sorry, I hate to do it, but we have to keep our recordings
I just didn't
consistent.
want anything to be close to a holiday like 4th of July was, we went through this year.
Yeah, that was fun.
Okay.
The Festival of Horse one was fun too. I don't remember what day that is.
I think it's the 2nd is the one listed for the 4th of
July
July.
the 2nd.
Yeah. Would we like to maybe move it to the 1st? Or, because last year, I think it was on, the 4th was the Thursday, so we moved it 2 days early to be the Tuesday. Because I believe when I went in and changed that, I didn't have to make any differences for that one.
This is July 6th.
So is that something we'd like to
What day is the 4th
consider?
on?
It is a,
Well, this is, the 2nd's on Thursday.
July the 4th
Yeah,
is
so
on a Saturday.
it's Saturday, yes.
That ought to be fine.
I guess just leave it.
I mean,
Do you know when the Festival of the Horse is going to
That's
be?
what I felt like it was, like Charlie had to run through all those people to get your Festival of Horse. I'd find Hunter Park.
Oh,
Like that is the only one.
Yeah.
It doesn't bother me, just be one to think about.
Yeah, but, I mean, we've parked like that for the last
That's-
decade, he's
that's
got
fine.
to
I
give
don't
himself
mind.
time,
It's
yeah.
fine. It's just
Yeah, we
something-
can avoid it.
Yeah, that's what I was
Yeah.
gonna say, is if it's
Yeah.
avoidable.
Red, do you know when or
I'm
Holden, do you know
trying.
when
I mean,
it would
I
be
went
announced?
here and went and saw people at Chili Cook-Off.
Yeah, it was
There you
nice.
go.
You could walk in the street to get here, but you had to walk in the street.
I will say that it was September 5th through 7th. I would imagine they'll keep the same
So
weekend.
it's the first week, right?
Typically, it's the weekend of
Yes.
planning commission.
It was the first full week of September.
Then what's the third following?
That'd be on Thursday.
It's the
Which
Thursday
do-
before.
It'll still be the Chili Cook-Off.
So the roads would be closed.
Yeah,
But September, you're talking about September?
Yes.
The 3rd wouldn't be the first full week.
No, it's
I mean,
the
I'm
half
just,
week.
maybe it's the first weekend. I couldn't
I was
say.
just,
I
yeah,
think it's
Yeah.
usually, is it the weekend after Labor Day?
the next week would be the first full week.
Was that what it was this year? Because I don't think it was Labor Day weekend. I think it was the weekend after.
The first was Labor Day.
Yeah, so I
Not
think
that
it's,
necessarily means-
I think it's the first full weekend.
Yeah, so it'd be the first weekend after.
Yeah.
Labor Day holiday.
Which is,
The 11th, 10th, 11th, and 12th.
So then there
no,
won't be,
then we'll be
It's the
fine.
second weekend.
yeah, so it'll be fine this year.
Yeah, I think it's the
yeah,
weekend
that
after
makes sense,
Labor
'cause
Day.
they wouldn't want people, there's no reason to throw something like you all say, I assume we're getting at is throw a party for people that are already out of town. You know, so yeah, that probably makes sense.
We can monitor it too. If we identify an issue for it and we get enough notice, we could potentially
It's
adjust
fine.
it
I
accordingly.
I'm here.
Yeah.
I'm here. It's just
You're gonna go to the
fine.
horse festival?
It's just
I'm
a
going to ask
thought.
Charlie, on that lawsuit, where are we at on it?
Well, we need to make a motion on this
Oh,
calendar, though,
Yeah,
don't
let's just
we?
get that, and I'll tell you, we were in court for that.
Okay,
Do we need to do the calendar first, get the motion?
Yes.
okay, I'm sorry.
Take a motion to approve the 2026 Board of Adjustment calendar.
I'll second.
Oh, who
I'll make a motion.
Oh, you did.
She'll second. All in favor, aye?
Aye.
Yeah, it'll work.
Sorry, Janet.
All right, motion passed. Okay, now, update on the law thing. report.
Everybody has briefed it, we had oral arguments today in court. Holden was there to watch the mayhem. The judge said he would have us an answer after the first of the year. He didn't say no later than something, he just said after the first, what we're going to do the rest of our lives.
Is it quite emotional again?
No,
Okay.
no, I still totally disagree with their attorney, and he totally disagrees with me, so, you know, we kept it honest in that sense.
There you go.
But no, otherwise, I think it went well. It just depends on, obviously, if the judge agrees with me, and I think he will, so, but we won't know until sometime after the first of the year.
You pray for discernment.
In the meantime, is she
That's exactly
still,
what I did.
in the meantime, is she still operating her business?
In the meantime, she is still operating. Holt and I had that discussion with one of the neighbors up there today, and we're gonna be meeting about that, and we can report on that next meeting if you want.
Because she shouldn't be, right? Didn't we give her a cease and desist?
Well, no, she is, there's no question, she is. And this is not out of the ordinary. I mean, what's out of the ordinary is because of the multiple applications and all, she's been doing this for a long time. We've had people in the past who've operated while suits are going on. It's just, this is so long because she's had a first, she was doing it without permission, she didn't file the first application, then she filed, you know, second.
Waited 2 months.
So
Yeah.
this is, in that sense, gone on longer than.
Did you bring that up in the hearing?
No, and I know you'd kick my rear end if I didn't, but that really wasn't part of the record, and so I'm not really supposed to do that. I had a kind of wicked little boy look in my eye for a moment, and I thought, no, I better not do that. So,
You were sitting on that.
I chose to make you mad, not the
Next
judge.
time I'll go with you.
Sidebar.
All right.
Okay, that was my question.
All right, is that everything? Meeting adjourned.
Happy holidays.